Mary, how are you?
I'm good, Paul. Good to see you again.
Good to see you again. This is Sarah Montoya.
Ms. Montoya, thank you for coming today.
And this is our court reporter. I'm Paul Redfern.
Linda Stephen.
Nice to meet you, Linda. Nice to meet you. This is Sarah, of course.
Hi, Sarah. Nice to meet you.
She's going to be taking down your testimony. So
Okay.
here's what I'm going to do is I'm going to have you sit right here, Sarah.
Okay.
And then I'll sit right here. So go ahead and have a
Paul,
seat.
excuse me, if you wouldn't mind, I would like Sarah to sit here, please.
As long as you promise not to reach out and hit her or anything like that, that'll be good.
Promise.
All
Thank
right.
you. I appreciate
Go
it.
ahead and have a seat.
Thanks.
Ms. Montoya, will you please raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I'd rather not swear.
Would you affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Counsel, should we follow the usual stipulations?
Well, I'm okay with that as long as I understand what those stipulations are, and that would be my major concern. I'd want to know what stipulations you have in mind. A couple things that I'm concerned about that is that I want my client to have the opportunity to read and sign the transcript, and I would suggest that all objections are preserved for the record except for objections to the form, and that's what I would propose.
I would also ask that Ms. Montoya read and sign her deposition. I would ask that she do that. And to be a little bit more specific about the stipulations, simply can we agree that any objection to a question that could be cured by reframing that question is waived if it's not made during the course of this deposition?
I'm good with that. I'm good with that.
Okay. Counselor, I also see that you brought Mr. Wilson with you here today. His deposition in this matter is not scheduled until tomorrow at 10 o'clock a.m. So I'm asking you to please have Mr. Wilson leave the room.
Well, I don't think we can do that. Mr. Wilson is a corporate employee, and he is our corporate representative. And because he's the corporate representative, as you know, he would have a right to be here the same as a party to the case. So it's our position that Mr. Wilson has a right to be here under the rules.
Well, if you're going to have Mr. Wilson here as a corporate representative, I will agree to that with the understanding that if you have a corporate representative in the future from your client, that it has to be Mr. Wilson at all. He'll be your designated corporate representative.
Well, I don't know about that. I don't know that I can agree to that.
Well, I don't think it would be fair for you to have multiple parties or individuals be here throughout the deposition. So I think we're going to have to call the judge and get a ruling.
That's fine with me.
Good afternoon again, Ms. Montoya. Could you please state your full name and give the court reporter your address?
Sarah Montoya, ABC Apartments at 63rd here in town.
As your attorney has probably told you, I'm going to be asking you some questions today to find out what you know about the conditions at an apartment building called ABC Apartments, which is located on 63rd Street. And I'm going to take you back to the time period of about December of 2012. So you understand that?
Yes.
Okay, that's the purpose of our deposition today. During the course of this deposition, if you do not hear or you don't understand a question that I ask you, will you please let me know that, and I will repeat or rephrase the question.
Yes.
Fair enough?
Yes.
Okay. If you answer a question that I ask you this afternoon, I will assume that you understood that question and have given your best answer. Do you understand?
Just a minute. I object to the form of that question for this reason. You may have one understanding of the terms in your question, and she may have a different understanding and think she's communicating with you, particularly with technical terms. She may have one understanding of a technical term, and you may have another and believe that she understands the question when she doesn't. So that's really not fair to the witness, and I have to object to the form of the question for that reason.
Well, Ms. Montoya, we'll both try this afternoon to be as clear as we can, but if I use a technical term or a word that you do not know or understand or want to find, let me know that. I'm glad to do that. Fair enough?
Yes.
Okay. Also, this deposition may take a couple of hours this afternoon. If at any point in time you need a break during the course of the deposition, let us know that. We'll be glad to take a break. Usually we try to take a break once an hour so everybody can get up and stretch.
Okay.
All right, fair enough?
Yes.
The only thing I ask is that if I have a question pending, that you first answer that question before we take the break. All
Okay.
right? Thank you. When the deposition in this matter is completed, our court reporter, Linda, will be typing up a transcript. And that will be a reflection of the questions that I ask you and the answers that you've given. And at the conclusion, once the deposition transcript is typed up, you'll have an opportunity to read it and then make any corrections that you want in terms of how it was transcribed. You understand?
Yes.
I wanted to start off the deposition this afternoon, now that we've talked a little bit about the ground rules, by asking you about your educational background.
Sure. I graduated high school in 2005, and I graduated from university in 2009.
And following college, can you tell me a little bit about your employment background? What did you do following college?
Let's start with some questions about the physical layout of the deposition here. Paul, at the beginning, you expressed some concern about the window being across the way from your witness. Is that something you would be alert to in real deposition practice?
Yes, it is. The reason that I would be concerned about the window are a couple of reasons. One, I don't want my witness to be distracted by what's going on outside the window. And equally important, maybe even more important, is if there's glare coming in through that window, such as sunshine or something of that nature, that can be very wearing on a witness, and it'll wear them out and makes them tired even though they don't realize it. So usually if there's sun or something of that sort, if I can't sit with our backs to the window, I'm going to ask that the shades be drawn.
And how about you, Mary Lee? Would that be a concern?
Right, that's a very reason, from my perspective, when I'm taking a deposition, that I have the witness face the windows. I want them to be distracted. I also asked that the witness switch chairs with the counsel because I want that witness directly across from me so that I have good eye contact with that witness. I think that makes them a little bit more uncomfortable when I'm questioning them.
Paul, you suggested that the witness should be sitting not right next to the court reporter, as is normally the case, but one over, and you would be next to the court reporter. But you backed off that pretty quickly when Mary Lee made her request. Is that something you care about?
Not normally. Actually, it's pretty traditional in a deposition where you are, it's not videotape where the witness will be seated across from the questioner. It's also more convenient for the court reporter in handling exhibits and so forth. So no, that's not normally something I'd be concerned about.
How about with a videotape deposition?
Videotape deposition is a different story. There are a number of things that you have to be concerned about. Number one, you always want to check the picture on the videotape deposition before the videotape deposition begins. You want to be sure that the camera is not pointed down at your witness. That will make your witness look diminished. You also want to have the camera directly on the face of your witness. And the major concern that we always have in videotape depositions is a situation where your witness is constantly looking away from the camera like I'm doing right now. The problem with that is it doesn't look like you're talking to the audience, number one. And truly the audience is the camera. And second, it makes the witness and can have a tendency to cause a witness to not look credible.
How about you, Mary Lou?
Right, I think Paul's points are well taken, that it's really important for you as the attorney who's questioning the witness to take a look at exactly how the frame up of the witness is. So often we don't check that, and it should be checked periodically throughout the deposition because witnesses will move or change their positioning, and you really want to be sure that as much as that's a film, if you can have some sort of eye contact, or at least it looks like the witness has eye contact with the jurors. I think that's important. And oftentimes, as time goes on, it gets a little sloppy in the deposition. We have to make sure that that's a sharp image for the jury.
Yeah. If I could just chime in on with respect to seating, I typically anticipate, if I'm going to be the interrogator, that there will be a request that the witness not be facing the window. And so I will set up on the other side of the table in the first place. And a second reason for doing that, and I can't prove this to anybody's satisfaction, but I kind of like the idea that I am positioned between the witness and the door. And I I just have the sense that the interrogator has a little more control that way. There are times when I have stuck to my guns on what Paul started off to do, and that is to take the seat normally reserved for the witness and stay there. Often the court reporter will object to that and say, I need to hear, and you can typically deal with that by saying, if you have any trouble hearing, just say so. But I would do that in a case where I was somewhat concerned that my opponent was not only aggressive, but overly aggressive, and I wanted to be in a better position to put my hand up and kind of let the witness know, hold on, rather than having to lean into the shot. Mary Lee, early in this deposition vignette, you asked to have the other deponent who was going to be on the next day, Mr. Wilson, sequestered. What was that all about, and would you normally do things that way?
Well, the reason that I brought that out was Mr. Wilson was going to be deposed the following morning. And obviously the intent of the counsel in bringing Mr. Wilson there was for him to have an opportunity to anticipate the type of questions that I might ask Mr. Wilson. And also to get some familiarity with my demeanor and the manner in which I ask depositions. And so I objected because I don't want to give him any advance notice. I don't want him to know what the issues are that I'm even going to address with this particular witness that's in the room, because I think that that's a tactical advantage. Also, I brought up the objection that, yes, although counsel brought up the fact that you can have a designated corporate representative, if you're going to designate someone, then it's usually my position with the judge is to say, okay, then Mr. Wilson will be your designated corporate representative throughout the entire process of discovery, and he will also be your designated corporate representative at trial in the event the judge rules that the witnesses will be sequestered at trial.
Okay. As a technical matter, Rule 615, which has to do with sequestration, does not apply to deposition practice, but what we saw in this vignette, I think, is typically what happens in fact. That is, everybody acts as if it does apply so that you're entitled to have a corporate representative present. Paul, there was a very small hitch, or perhaps not even that, when the witness said that she did not take the oath, and the reporter immediately asked, well, do you affirm? Is what we saw there pretty typical of what happens?
It is typical in my practice. Normally, what we see around in my practice is most court reporters ask a witness whether they swear or affirm. So it's pretty typical. It doesn't raise much controversy in most cases around the country, actually.
Yeah. In terms of the discussion about having the deposition read and signed, and I think it came out here that, okay, it would be read and signed, what would you do typically in day-to-day practice, Paul?
Usually we enter into a stipulation that it depends on the rules of each jurisdiction, but usually the stipulation we enter into is that the witness will have the right to read and sign it. And if I want my witness to read and sign the deposition, then we'll do that. If I'm the lawyer taking the deposition and the issue comes up about reading and signing, usually we'll enter into a stipulation where the deposition can be used as though read and signed if it's not signed at the time of trial. That becomes important under certain rules about using the deposition for cross-examination or impeachment at trial. So that's normally how I would handle that issue.
Sometimes I think our problem with that, and I do think it's a good idea for witnesses to read and sign depositions, but as we all know, sometimes we work with expert witnesses and, for example, doctors in medical malpractice cases, and getting them to read and sign sometimes can take, a month or 2 months to have them read and sign a deposition, and that slows down our process in terms of getting those deposition transcripts out to our clients and getting them to our experts or consultants in a case. So normally what I will do is say, if the doctor wants to read and sign the deposition, that's fine, but in the meantime, I ask the court reporter to provide counsel with a copy of the deposition so that we have it to use in our discovery process and it doesn't hold matters up.
Right. As Paul cautioned on this subject, as on every other, you need to know what the local rules are and the local practice. It used to be so under the federal rules that the witness was supposed to sign unless signing had been waived. And now the rule has been changed so that it need not be read and signed unless one of the lawyers makes such a request before the deposition is over. Mary Lee, in terms of where we came out, or where you and Paul came out on the so-called usual stipulations about reserving objections as to the form of the question, and you then came back and said, well, you would have to make an objection if it could be cured by reframing the question. In day-to-day practice, is that normally where things would work out?
Well, again, I think it's a jurisdictional thing in terms of what the particular state in which you practice requires. But generally speaking, I think you have to make your objections as to the form of the question on the record in order to protect those objections. So if someone objects to form, and oftentimes someone will just say object to form, which I don't think is a proper objection, then I will say to them, what's wrong with the form of the question so that I can cure it at the time of the deposition. Because I don't want to waive that, particularly if it's an important question in my examination. I don't want a judge coming back and saying, well, the question wasn't proper to form, so I'm going to strike that, which they could do. So you always want to try to cure it in the deposition if you can.
How about you, Paul?
My normal practice in handling all of that as far as stipulations are concerned is I will usually say that we're going to follow the rules of whatever jurisdiction we're in. And that is how I handle it. And of course you have to know what the rules are in the jurisdiction. And I don't like to enter into any stipulations beyond those rules. Some jurisdictions only require that you simply state objection to the form, and you're not required to do anything further. Although I think what Mary says is a good practice when there's a key question and somebody has made an objection to the form, even though that person is not required to set out the reasons that they're objecting to it under some rules. For example, the federal rule, you would not have to. It's a good idea because I think the judge becomes more lenient on those questions if you have asked for help from the other counsel on a key question like that. If the other counsel won't set forth what those reasons are, then what I will do is I will frequently have the court reporter read it back to me. I want to make sure, and I'll listen to my own question. For example, the jurisdiction that we're sitting in here today, an objection to the form would not preserve anything. You have to state the reasons for your objection if it's to the form of the question so that the questioner has an opportunity to correct the form of the question.
Yeah, my own preference is that if I am the interrogator, the one taking the deposition, I like to take the same approach as Paul has described, which is we'll play by the rules. And the reason for that is that under the federal rules and under most state systems that I know of, in general terms, the fellow in the generic sense on the other side of the table has to object if the objection is one that might be obviated at the time of the deposition. So certainly an objection as to form fits that description. But there's another kind of objection that fits that description, and that is the absence of foundation. And if you have a stipulation that says that all objections as to form, all objections except as to form are reserved until the time of the trial, then you're at risk of having somebody come up with a lack of foundation question, which you could have cured at the time of the deposition. Conversely, when I'm on the other side, representing the witness, and people want to say that, well, you only have to object if you object to the form of the question, well, that's fine, because that makes my job easier, and it's the other fellow that's put at risk, not me. Mary Lee, the kind of the outline of the questioning here was, I think, fairly typical of what you see at a lot of depositions. You gave the witness what I think of as her civil Miranda warnings, saying if you don't hear the question, say so, etc. And then you went to her educational background, and then her employment history, and then you were obviously starting a chronological development of the facts as known to the witness. Is that the way you would typically do it?
I think it depends on the witness. Oftentimes, if it's a lay witness who's uncomfortable with the deposition process, I will start out with some of the background information about their education, background in training, employment, because it alleviates a little bit of their anxiety. And if you notice when people give responses to educational background and employment, it's a little bit of a narrative. So they get comfortable with the narrative idea, where I'm sure their lawyer has said, just listen to the question, answer it yes or no, and don't volunteer any additional information. My goal is when I do a discovery deposition, I'm going to get as much information as I can from that witness. So if I can start them off on a narrative frame in the way in which I ask the questions, then sometimes they continue that as they go through the deposition process. If it's a question of, where I know I'm deposing, say, an expert witness, for example, or a doctor in a medical case, and I've got their resume or their CV, I want to get as much of the critical information as I can get during the course of that discovery deposition, and I might be pressed for time. In other words, a doctor may say, I've only reserved 3 hours, and you've got to get this deposition completed. Then sometimes I will start to the heart and the meat of my case. And I do that because I might as well hear what his opinions are, and it gives me time during the course of the deposition to kind of think about what he's testified to and go back to certain subject areas if I need to go back to them, to make sure that I've zeroed in and found out the basis for all of his opinions. And then whether I get the educational component and all that background information isn't quite as key, because I've got their resume or their curriculum vitae, and all of that's contained in that document. And it's also a matter of, how long, what our attention span is and how sharp we are. I'm always sharper at the beginning of the deposition than if I'm into a deposition for 3 hours. You get a little tired, the witness gets tired, and you do too. So why not save some of those kind of routine questions to the end? So it depends on the witness.
How about you, Paul?
I think it does depend on the witness, and I think it also depends on the purpose for which you're taking the deposition. There are witnesses that you may be more confrontational, and you may actually plan on presenting that testimony to the jury, and so that may dictate a different approach. For example, if you're going to do that and it's going to be a deposition that you want to play in front of the jury, you may hit them with very, very important questions from the very beginning, with the idea that it's not really a discovery deposition. It's not a deposition to find out information. It's more to present some testimony right away to the jury. Most of the time, in most depositions, I consider them to be discovery depositions. Although discovery depositions are always mixes of discovering information and also getting information to help your side of the case. And I'm trying to build rapport with the witness. So I usually will start off with the typical background information, so I have an opportunity to build rapport with that witness, get a chance to, so to speak, bond with that witness, so that that witness feels comfortable in telling me everything. So I like that to happen.
Yeah, with the so-called civil Miranda warnings, I think a lot depends on who the witness is. For example, if you're taking the deposition of the vice president in charge of sales for a Fortune 500 company, I don't think that you need to go through the Miranda warnings. At least I would not do it. And I would not do it because I'm not worried that we'll get to trial and that he would say, by way of explanation, well, I didn't really understand the question, but I didn't realize that I could ask for clarification. I think, if anything, he would make his testimony worse by saying something of that kind. Something that I thought was done very well by the interrogator in this case was that she went through each of the questions and then got an answer from the witness. If the question is not clear, will you tell me so I can clarify it for you? Answer yes. An advantage of doing that is if you get to trial and the witness says, well, she really did not understand the question, it's nice to go back to that discrete instruction and that answer and focus right in on it. If you've read 10 or 12 different things and at the end of it the witness says, yes, that's okay, the judge may say, well, you have to read the whole thing. You just don't have the same control. And in terms of the kind of thing Mary Lee was saying about starting with the key fact or key meeting, I'm reminded that one of my colleagues in Philadelphia who handles a lot of serious medical malpractice cases says that on occasion he will ask the defendant doctor a question along the lines of why did you perform a cesarean question or cesarean section here? And he will ask that right out of the chute after getting the doctor's name and address. And he says sometimes it works out great, and sometimes the doctor begins an answer that goes for about 25 pages, which he can't interrupt because he asked the question, and he said he has the feeling that he's in the middle of a thicket that he's never going to get out of. So I would take 50 or 100 depositions before I tried something like that. One way or the other, you'll get out of it, but it may be a battle.